What is the difference between a business association and a partnership? In today's fast-paced business world, understanding the differences between business structures is more important than ever. Just yesterday, many entrepreneurs were searching for clarity on the distinction between a business association and a partnership. This topic is trending as more individuals consider starting their own businesses. Let's break down this question from a business law angle. A business association is a broad term. It covers any group of people or entities that join together to conduct business. This includes corporations, limited liability companies, cooperatives, and partnerships. The term does not refer to one specific legal structure. Instead, it is a category that includes several types of business entities, each with its own rules under the law. A partnership is a specific type of business association. It is a legal relationship between two or more people who agree to share the profits and losses of a business. Partnerships are governed by partnership agreements and, in many places, by statutes like the Uniform Partnership Act. In a partnership, partners usually have unlimited personal liability for the debts and obligations of the business. This means if the business cannot pay its debts, creditors can go after the partner's personal assets. Now let's compare the two. A business association can be a corporation, which is a separate legal entity from its owners. Corporations have shareholders, directors, and officers. Shareholders usually have limited liability, meaning they are not personally responsible for the company's debts. Corporations must follow formalities like holding meetings and keeping records. A partnership, by contrast, is not a separate legal entity in the same way a corporation is. Partners manage the business directly, unless they appoint a managing partner. The partnership itself does not pay taxes. Instead, profits and losses pass through to the partners, who report them on their personal tax returns. Another key point: forming a corporation or a limited liability company usually requires filing documents with a government agency, such as articles of incorporation or a certificate of organization. Partnerships, especially general partnerships, often do not requiring formal filings to exist, though it is wise to have a written agreement. In short, all partnerships are business associations, but not all business associations are partnerships. The main differences lie in legal structure, liability, management, and formal requirements. Partnerships are simpler to form and operate but come with greater personal risk for the owners. Other business associations, like corporations, offer limited liability but requiring more formalities and paperwork. This distinction matters in business law because it affects how a business is run, how it is taxed, and how much risk the owners face. Choosing the right structure depends on the goals and needs of the business owners.